All right, President Joyce, we're all set.
Good morning, everyone. This is Rich Joyce, Board President of the Oregon Board of Pharmacy. I will now call this meeting of the Oregon Board of Pharmacy to order. Today is Thursday, June 11, 2026. It is 9:57 a.m. Board of Pharmacy meetings are conducted in accordance with the Oregon Public Meetings Law. Under the Public Meetings Law, governing body meetings are open to the public except as otherwise provided by law. The presiding officer has the authority to keep order and to impose any reasonable restrictions necessary for the efficient and orderly conduct of a meeting. Governing bodies are authorized by ORS 192.660 to meet in executive session in certain limited situations, including the consideration of information obtained by a health regulatory board as part of an investigation of licensee or applicant conduct and consulting with counsel concerning the legal rights and duties regarding litigation or litigation likely to be filed. All official actions by the board must be taken by public vote, and the vote of each member must be recorded. Our mission, the Oregon Board of Pharmacy, serves to promote and protect public health, safety, and welfare by ensuring high standards in the practice of pharmacy and through effective regulation of the manufacture and distribution of drugs. The Oregon Board of Pharmacy is committed to diversity, equity, inclusion, and belonging, DIB, within its organization for the public it serves and for the public it serves. This commitment is reflected in board membership, agency staffing, the services provided, and its efforts to promote patient safety and ensure access to quality pharmacy care. The board encourages review of its full 2024-2026 DEIB plan located on the board website. We'll now call roll for board staff. For the record, when I call your name, please verbally acknowledge here. Board President Rich Joyce, Board Vice President Amy Kirkbride.
Here.
Board Member Kat Chin. Board Member Jennifer Hall.
Here.
Board Member Victoria Kroger.
Here.
Board Member Priyal Patel.
Here.
Board Member Brian Smith. Here. Chief Compliance Officer Joe Ball.
Here.
Vice Director Brianne Effermoff.
Here.
Compliance Officer Dana McComas.
Here.
Operations Manager Rachel Melvin.
Here.
Executive Director Gary Renyon.
Here.
Board Counsel Angela Hunt.
Here.
For public information, a public comment will occur towards the end of the meeting on Friday. The board will not deliberate any issues or requests during public comment, such as formal requests, issues currently under investigation, requests pending before the board, or currently proposed rules. Public comment is limited to matters that were noticed on the board meeting agenda, and comments will not be allowed that are longer than the time allotted by the chair. To sign up for public comment, email your request to pharmacy.board@bop.oregon.gov by noon on June 12, 2026. For the record, board member Anna Pineda will be joining us at 10:30 a.m. Now to review some housekeeping items and meeting etiquette. Please identify yourself as, quote, board staff member last name, quote, each time you speak. Speak one at a time and directly into the microphone. Raise your hand when you have questions or comments and silence all devices. Please note that this meeting is being recorded and retained for public record purposes. Okay, we will begin with the review of mailing A with staff member Melvin.
All right, in just a moment. Okay, staff member Melvin. Again, this is mailing A. This is our hearings officer's report from our rulemaking hearing. And I will just scroll down here for the report. On April 15th, 2026, the May 2026 notice of proposed rulemaking hearing was publicly noticed via Gov Delivery to 5,331 rulemaking and adopted rules subscribers, and I sent it to 20,014 licensees and registrants. Interested parties were invited to sign up and to provide oral testimony during the hearing. The hearing convened at 9:30 a.m. and it adjourned at 9:44 a.m. 8 people attended the hearing. No participants signed up or provided oral testimony during the hearing, and the board received 4 written comments, which you all have been provided with. through the open comment period, which ended on 4/17/20. I'm sorry, it ended on 5/26/2026 at 4:30 p.m. And the rulemaking hearing was related to our Division 115 rules, where it would permanently adopt our protocols for MOUD and amend our Division 115 rule. And it also was related to our proposed drug compounding rules, as well as our fund standards adopted by reference. Back to you, President Joyce, for consideration of voting to adopt the report.
Sure. Is now a good time to comment on acknowledging the comments, basically, or should we just?
We probably want to do that. This is just about the report. We will have an opportunity for that when we
Okay.
present the drug compounding rules.
Sounds good. Should we go ahead and motion then?
Yes, it's board's ready.
Is there a motion to move to accept the May 2026 rulemaking report? There a second?
Second, Board Member Kirkbride.
Board President Joyce, yes. Board Vice President Kirkbride,
Yes.
Board Member Chin,
Yes.
Board Member Hall,
Yes.
Board Member Kroger,
Yes.
Board Patel,
Yes.
Board Member Smith. Motion passes. We will now consider adoption of rules, starting with mailing B with Staff Member Melvin.
Thank you. Staff Member Melvin. Again, this is mailing B. This is related to medications for opioid use disorder protocols and continuation of therapy. Again, this is the rule for Division 115 that permanently amends our current temporary rule, and it amends paren 1 by revising the continuation of therapy protocol by removing the language related to early refills of non-controlled opioid use disorder medications as mandated by statute. And then it proposes adopting 2 new protocols in 3(j) and K for MOUD, initiation of care, and continuation and modification of care. I am just going to turn this back to you, President Joyce, to open it up for board discussion if anyone has comments about the proposed rules.
Okay, let's go around the table. Board Member Kirkbride,
I don't have any comments. Thank you.
Board Member Patel,
Comments?
Board Member Smith. No comments. Board Member Kroger,
Comment.
Board Member Chin,
No comment.
and Board Member Hall.
Comment. Thank you.
Member Joyce, nothing to add at this time. Thank you. She's not here. It's 10:20.
Okay, President Joyce, so back to you for motion to permanently adopt.
Great. Is there a motion to adopt OAR 855-115-0345 as presented to be effective upon filing?
So move, Board Member Kirkbride.
Is there a second? Board Member second. Board President Joyce, yes. Board Vice President Kirkbride,
Yes.
Board Member Chin,
Yes.
Member Hall,
Yes.
Board Member Kroger,
Yes.
Board Member Pineda. I'm sorry, Board Member Smith. Yes. Motion passes.
Oh, I'm sorry, Board Member Patel. I did.
Board Member Patel, there you are.
Yes.
Okay, motion passes, and Board Member Patel will be joining us at 10:30 a.m.
Board Member Pineda.
Sorry, this is
It's okay.
my final lap. Here. And then, it hasn't kicked in yet.
Yeah.
You want me to recall the motion, or? Okay, thank you. Motion passes. We will continue with mailing B1 to the drug compounding, starting with Staff Member Melvin.
Thank you. This is mailing B1. This is related to Division 6, 41, 43, 45, and our proposed 183. I am going to turn it over to Staff Member Efremov for some board discussion.
Thank you, Staff Member Efremov. Just to also orient the public to the public feedback comments were received in mailing A related to the mailing B1. Staff would like to start by giving a huge thank you to all parties that participated in the rule process. That includes the 9 members the compounding work group that met for 5 meetings in 2023 and provided recommendations to the board. The 62 comments received in the rule feedback process, the 4 additional comments received in the rulemaking process, and the expertise and assistance in drafting the rules from subject matter expert Natalie Gustafson. We greatly appreciate the time and energy that everyone has put into this process. I wanted to take a moment to address the additional comments that were received and provide the board with necessary additional information. The board has received additional overall support for these rules and specifically support for language that provides an allotment for non-patient specific compounding for specific circumstances for veterinarian use only. Further comments were made regarding 503B or outsourcing compounding. Staff will keep these in mind as we update the manufacturer's rules and create a division for outsourcing facilities, which are currently in process. We can assess the certificate of analysis for API or active pharmaceutical ingredients when revisiting these rules. There was one suggestion on how to address the prohibition language, as it appears the suggestion is to return to the board's previous language to clearly state that carpet is prohibited and adding the additional term rugs to collectively state that carpet and rugs are not permitted. The board also received comments regarding valid patient safety concerns related to 503A or pharmacy retail drug compounding. Many similar concerns were raised in the initial feedback comments. Overall, the comments focused on enforcing federal regulations. These comments warrant further information for appropriate board assessment. So I would like the board to orient the board to a relevant Ninth Circuit Court ruling. I'm going to pause while staff member Melvin pulls this up for the public. We won't read or take the time to read this full document. I'll give you a summary of this, and we will provide a link to this document in the public minutes. And the board members have this available to be able to look at also, but further analysis can be done later. The conclusion of this case is that only the FDA may enforce the Federal Food, Drug, and Cosmetic Act, or better known as the FDCA. This law is the primary law that grants the FDA the authority to oversee the safety, efficacy, and labeling of drugs. This means that the FDA gets to enforce the FDCA, and the board may write and enforce rules that are aligned, but the key point here is that these need to be articulated in the board's regulation to be enforceable by the board. Based on the comments provided in the initial feedback and in the current rules comment under review, some of the specific patient safety parameters outlined would need to be articulated by the board and rule to be enforced. It is important for the board to remember, as part of the initial drafts of the compounding rules, the compounding work group had recommended many FDCA requirements to be clearly articulated in rule, but later were struck as these requirements were deemed duplicative to being located in the federal regulations. In part of rules consideration and discussion today, staff are asking the board if you want to revisit these rules and add needed patient safety regulations that appear in the FDCA into these rules. Another side note that's important to consider before we begin a round robin, the board does have regulations in ORS 689-527 regarding adulterated drug and OAR 855-006-0020 regarding unprofessional conduct, specifically paren J. Any conduct or practice by a licensee or registrant with the board determines contrary to accepted standards of practice. This might encompass some patient safety concerning behavior, but not all things outlined in the FDCA will likely fit under these regulations. So at this time, I would like to get board input and discussion. So I will begin with a round robin. Or I could just hand it actually back. Why don't we just hand it back to President Joyce, if you want to go ahead.
Sure. I'll go ahead and start round robin. Board Member Patel, did you want to comment on this portion or what she just stated?
Can you bring that portion? Where is the portion? I'm still, that's the back.
So in summary, this document is a Ninth Circuit Court ruling related to enforcement of the FDCA, stating that it is the sole ability or jurisdiction of the FDA to be able to enforce this. So if the state would like to be able to, if Oregon would like to be able to have specific code or would like to enforce these regulations, you would need to have them in your rules specifically. So we can't refer or rely on federal regulations to enforce, only the FDA can enforce federal regulations related to the FDCA only.
Board Member Patel, I don't think so. I want to enforce. I don't want to change anything. This is looking great. Implied, no, I would not want to add all this other verbiage.
Board Member Smith, how do you feel about this?
Board Member Smith, I was wondering if it would be, maybe, I don't necessarily want to add in all the FDA like requirements that we now have to enforce, but I'm wondering if the board is able to come up with some kind of like creative ways to enforce these laws without directly referencing them. I don't know if that would be at all possible, just for the ease of getting these rules that we've worked hard on for several years on the books. I feel like we've spent a lot of time. It is unfortunate that I don't know how well and easy it will be for us to reference FDA requirements on things going forward. But maybe there's a way that we can enforce these laws with laws that we already have on our books. Because I do think it's important that we get these done. And this would, I feel like if we had to go through and add these all back in, I feel like that'd be like the setback. So maybe there's a way that we can kind of bridge that. That was an idea I had. Thank you.
Board Kroger,
Board Member Kroger, I think at this time, I'm not interested in entertaining adding anything to our current rules related to this at this time, but I do think that this might be something we want to revisit and reconsider in the future, but I don't necessarily want to go through, we're adding specifics, and I think it would be great to have a discussion maybe from board staff on kind of what items they would think would make sense within our rule, and really better understanding where we feel like what's in here, or maybe we would want to also have added to our rule, just better understanding the whys behind those certain items.
thank you. Board Member Chen,
Member Chin agrees with the last two comments and you don't have anything to add.
Member Hall,
Member Hall, overall, I'm fine with what we have. My concern is just how long it would take, to come back and to add something later. I mean, it could take time. It's my reluctance, but, we have worked on this for a long time, and I think what we have here is a good starting point.
thank you. Board President Joyce, there's definitely a concern coming from industry representatives and the public, regarding compounded meds. And legally, what the FDA has in rules and what the state can do, I want to see what we can do in the future to address some of those concerns. At this time, agreeing with everyone else, I don't want to kind of hold what we already set forth, but understanding the legality of what the FDA has, and the public concern, especially with the 503As and 503B sector. We definitely need to address those concerns in the very near future. Thank you. Member Kirkbride.
Point of clarification, so I understand, can we or can we not adopt them how they are written today? And they're just not enforceable? Or do we have to change the language before we adopt them because of the references to enforcing federal law. Could you clarify that for me?
Of course, staff member from that's a great point of clarification. So keeping in mind too, there are many federal regulations. So other statutes and federal laws and rules could still be enforceable. This is just carving out related to the FDCA. So the rules don't necessarily need to change in any way. You could adopt as is and enforce as is. As we did mention too, there are some other statutorial authority that the state does have, the board may use, that might get us there with adulterated drug and unprofessional conduct. So the big scaries, maybe for lack of a better term. And staff can look into further assessing what else might be necessary or would recommend when we do a crosswalk of this, and could bring that back to the board for the board to consider, understanding that these rules have been in process for several years now to be able to get something started initially. There's no harm in revisiting these at a future date.
Thank you, that's helpful. Yes, so my opinion would be that we move forward, with all the work that's been put in, kind of knowing that this issue exists, and then do some analysis and, potentially update these rules at a later date with additional comments regarding the federal things that, would be difficult to enforce as written. I do not want to have all that content added back in for sure, but I think that there are some select things that perhaps we could add back in that would cover the bulk of things that we might be missing in our existing OAR. Thank you.
I would hand it back to Board President Joyce to entertain a motion if you see fit.
Yes, so I'd like to ask the board, are you comfortable going ahead to motion to adopt this? Is there a motion to move to adopt OAR 855-006-0005, OAR 855-041-1018, OAR 855-043-0545, OAR 855-043-0630, OAR 855-043-0740, OAR 855-045-0200, OAR 855-045-0205, OAR 855-045-0210, OAR 855-045-0220, OAR 855-045-0240, 855-045-0270, OAR 855-183-0001, OAR 855-183-0005, OAR 855-183-0010, OAR 855-183-0015, OAR 855-183-0020, and OAR 855-183-0030 as proposed to be effective upon filing.
Board Member Chin.
There's a second.
Second, Board Member Smith.
President Joyce, yes. Board Vice President Kirkbride.
Yes.
Board Member Chin.
Yes.
Board Member Hall. Board Member Kroger.
Yes.
Board Member Patel.
Yes.
Board Member Smith.
Yes.
Motion passes. Yes. So, yeah.
Staff member Effermoff would like to add comment.
Yeah, staff member from I thought it would just be important for the public and the board to know the next steps, since there are some moving parts related to this. And for clarification to the public, I know Division 41 Division 45 was cited, right? Or 43, 45 was just repealed. So 183 is going to be the compounding rules moving forward. And now that you've adopted them, we need to make sure that you were aware staff is going to need to update our inspection process. So we are going to need to update our self-inspection forms to meet these new regulations. Staff is currently looking into and will look into further the NABP Multi-State Inspection Blueprint Program. We'll bring more information back to the board as we learn more. Just so the board is aware, the Blueprint Program creates a standardized process across states that requires the following. You either use their or a jointly developed pharmacy inspection blueprint sterile compounding inspection form. It's reviewed by NABP to assess that it meets the pharmacy inspection blueprint standards. When you're inspecting, you will You agree that you will be using this inspection form. If you want to use your own, you need to create a complete crosswalk and compare that with the NABP standards to make sure it's in alignment. We are required to then attest that the inspectors who conduct these inspections are trained through NABP or an NAB approved provider. And NABP will provide training at no cost. So that is a definite advantage if we were able to utilize that. We also would have to agree that board inspectors, compliance officers will continue to participate in ongoing training as required, which is something we already do. So already in alignment with that. And that sterile compounding inspections will occur at no less than every 24 months. And that we are willing to share those inspection reports with other states, which we currently already do also. So there's approximately 20 other states in the program. We think this would be a great use and resource of staff's time and also to help standardize that process. Another key point that we want to highlight is per 855-0183-0015 effective November 1, 2027, non-resident drug outlets that prepare compounded product must be inspected and be in compliance with current USP standards. If a drug outlet's home state does not inspect and require compliance with current USP standards, the drug outlet, prior to obtaining or renewing a license, must provide evidence to the board that that drug outlet is accredited, certified, or received an approved inspection within the last 2 years. And we have the list of what the improved inspections are or accreditation. Staff will be bringing forth at a future board meeting as part of the SDA review to include a list of states that meet Oregon standards. This will include regulations inspections a minimum of every 2 years that would be able to be accepted. This will also be updated annually as part of the SDA review process. If a non-resident pharmacy seeks to send compounded product into Oregon from a state that does not meet our compounding standards, they will need to provide evidence of an approved accreditation or inspection. Those listed, the PCAB, CCE, NABP, and Joint Commission are all already pre-approved. If the outlet would like to request a different accreditation or inspection program, they are permitted to do that, but it requires board approval. So if the board does receive a request, that will have to come back to the board for the board to review and to add that to the SDA. So at that time, the board does we'll just keep adding to the staff delegated authority review process. So every year that will be reassessed to see if that is still a valid program. And we'll keep that as a public document so the public can be made aware of that. Is there any questions from any board members regarding any of the follow-up processes?
Questions?
Thank you very much. Thank you all very, very much. I know this has been a very long process, so you did really great work here today. Thank you.
Thank you. And we'll now review mailing B2 standards adopted by reference. Staff member Melvin.
All right, thank you, President Joyce. All right, this is our proposed permanent adoption for our annual standards adopted by reference, which will update all of the references. And this impacts quite a few rules. So this is Division 41, 80, 115, 120, 135, 139, and 141. Because this is just fairly simple and technical, I'm just going to turn it back to you, President Joyce, for board discussion and consideration of motion.
Does anybody have any questions? I'm seeing none. Is there a motion to adopt OAR 855-041-1046, OAR 855-041-1092, OAR 855-041-1145, OAR 855-041-0, OAR 855-041-7050, OAR 855-080-0020, OAR 855-080-0021, OAR 855-080-0022, OAR 855-080-0023, OAR 855-080-0024, OAR 855-080 0026, OAR 855-080-0028, OAR 855-080-0031, OAR 855-080-0065, OAR 855-080-0070, OAR 855-080-0075, OAR 855-080-0085, OAR 855-115-0130, OAR 855-120-0005, OAR 855-135-0001, OAR 855-139-0145, OAR 855-139-0350, OAR 855-139-0460, and OAR 855-141-0350 as proposed to be effective upon filing.
Move Board Member Kirkbride.
Is there a second?
Second, Board Member Smith.
President Joyce, yes. Board Vice President Kirkbride,
Yes.
Board Member Chin,
Yes.
Board Member Hall, Board Member Kroger,
Yes.
Board Member Patel,
Yes.
Board Member Pinedo is not here yet. Board Member Smith,
Yes.
motion passes. We will now hear from Executive Director Runyon about rules and development. On the zeros. One second. Is Board Member Pinedo on yet?
Not yet.
Director Runyon, go ahead.
Executive Director Onion. Good morning, everybody. Staff Member Melvin, could you pull up the checklist, the rules prioritization ranking? We have that accessible.
Yes, give me just a moment. Here we go.
Okay, Executive Director Onion, as you can see here, this is the most recently approved rules prioritization list adopted on 4/9/2026 or at the April board meeting. Of note, the board staff is continuing to prioritize all of the rules associated with the Drug Supply Chain Security Act or DSCSA. So that's on the top of our list going forward, as well as continuing to work on associated rules with House Bill 4131 from this legislative session related to the implementation of mobile pharmacies. In addition to that, obviously you see the work that we put in to get the compounding rule package to you and passed. Similarly, you'll continue to see the byproduct of all the work that's gone into the PPL rules a little later this morning or afternoon. So hopefully we can get those submitted and approved and in some workable form to hopefully get out to the public soon. And aside from that, I think that encapsulates the work that we're going to do near term to continue to move these rules in a way that coalesces or reflects with board direction. Joyce, I'll turn back to you.
Okay, let me start off with some discussion on this. Board Member Smith, I believe, you're next.
Or comments at this time.
You're okay with the? These are listed. Okay, Board Member Kroger,
Member Kroger, no comment.
Board Member Chin,
Member Chin has no comment. Looks good.
Board Member Hall,
Paul, no comment. Thank you.
and Board President Joyce. Timeframe wise, with the mediums, what are we looking at? Like maybe 2, 3 years? I mean, like frame wise, as far as like addressing those, what the estimate? It's like the medium. And just looking at it, I obviously red is urgent, yellow, soon priority. And mediums are more like what time frame?
Executive Director Running, I think there's a lot of variability within the medium category in terms of priority within that. I don't want to speak too generally. I think some of those could be 5 years out. Obviously, the Vision 41 is going to be a massive overhaul, and integrating that overhaul into our overall vision in terms of what the rules should look like going forward, and increasing the, I guess, end users' ability to kind of navigate those in a functional way. I think that's going to take a few years at least. So I'd be happy to entertain any thoughts from staff member Efremov, if there are any dissenting opinions from what I've stated. But yeah, I think some of the medium topics could be a good 5 years out, because that Division 41 overhaul and the cold drug storage rules, in addition to the DSCSA, taking priority, the Division 41 rules will probably take a few years at least.
And in terms of a discussion about like grace periods for outlets to have to not have a pick, I mean, is that ever it's discussed from time to time. And from what I understand, some states have it. Would that fall under high priority and their picks? Then if such discussion were to happen about a grace period for outlets to have to picks.
Executive Director, I think that would be high priority within the high priority item of Division 41. So that would be part of the pick package within the Division 41 package, if that's what you're asking.
Yeah, okay. And then lastly, I know I bring this up quite a bit, but it's been put in the parking lot for CPHT. I mean, if we're looking at a 5-year plan for generally speaking, for medium and then low beyond that, I mean, I would like to see CPHT at least initiating discussion in the low priority. I mean, I don't know how the rest of the board members feel about that, but if it's that far out, as far as like initiating any kind of discussion on that, I mean, I'd like to see that at least from the parking lot to put in low. Otherwise, only other option is, through legislature, but I don't know how, if that changes things too much. Is that something board members are willing to entertain? No, not really. Okay, that's fine. Yeah, I'll move on. Robert Kirkbride.
My comments just that telework remains a high priority for me, so I'm happy that it's in the high priority list, particularly having rules that support people who work in work settings that are not dispensing related, and increasing opportunities for technicians to have remote work opportunities. Thank you.
Thank you, Robert Patel.
Board Member Patel, I'll be looking forward to hear comments on mobile pharmacies. I won't be on the board, but I'll be very interested in what the discussion you guys keep. Thank you.
Director, anything else that you wanted to add regarding rules prioritization?
Executive Director, nothing else to add?
Thank you. So we'll now review and discuss mailing C and mailing C lowercase a related to COPD vaccine administration with staff member Melvin.
All right, give me just a moment. Okay, Staff Member Melvin, this is mailing C. This is related to pharmacy technicians administering influenza vaccine to a person 6 months of age or older. What we are proposing today is a temporary rule. So it would temporarily amend our current rule of 855-125-0305. And again, it's just very simple. It's just adding that pharmacy technicians may administer influenza vaccine to a person at least 6 months of age or older as mandated in 689-645. So we are proposing to amend, again, 855-125-0305. Per NB, we're adding the word and then we're adding a new little c to a person who is at least 6 months of age when administering an influenza vaccine, as it's carved out in statute. And then we've added the statute to our authority and our implemented. So I will just turn this back to you, President Joyce, for board discussion. I will just mention the mailing that's kind of tied to this. So we're presenting a temporary rule that we would file next week to be effective upon filing. And then our mailing CA would be the same exact version of this rule, but to send to our November rulemaking hearing.
Thank you. Board Member Kroger on this section or the
No comment. Thank you for, I guess, reviewing the statutes and making sure we're in line with that. Thank you.
Board Member Chen?
Chen, comfortable with the language and how it's written, and glad that there's information about the training aspects. I think that's the key to making sure that everybody's safe.
Board Member Hall.
Member Hall has no comment.
Is Board Member Pinedo up yet? Can we tell? Or Pinedo, are you there?
I don't see her on the call yet, sorry.
Yeah, okay. Is Board President Joyce, yeah, I mean, I appreciate this, definitely, thank you, Board Member, Kirkbride.
I did have one comment regarding section 2, where it does talk about the training. Just wanted to point out, paren A, competency in hands-on administration technique. While the primary training that someone would obtain, whether they're a pharmacist or a technician, does include hands-on technique, as far as I'm aware, the add-on training that you would take to administer anterolateral thigh for infants is not a hands-on training. There aren't infant volunteers that we practice on. It's a video webinar type thing to just learn the site, and so that's the type of training I did when this law came into effect. I believe this probably mirrors the pharmacist language, and we just took it from there. So I just for awareness, want the board to be aware that if we ever had a case come before us, I think we would have to fall back on the as approved by the board language for training programs, and just be aware that the person would have the primary hands-on training for IM and sub Q, but the anterolateral thigh would be a webinar type training. So there's not a good way to say that there. Just for awareness, so everyone knows that that piece for that site is most likely not going to be a hands-on training. Just wanted to bring that up. Thank you.
1 second. Go ahead. Jen.
This is remember, Jen, there have never been volunteer in this anterior thigh. I learned on the job for mine, so.
It's oranges, you can stab.
No, it doesn't count. They don't wiggle, they don't scream.
They can squirt back at you. Is Board President Joyce, could we put parentheses if applicable, hands-on? I mean, is that something that if applicable? No, it wouldn't change it, definitely. But do we need to revise? No, just comment.
Staff Member Effernoff, I think it's the board's decision on if you would like to revise it or not. I think what I hear Board Vice President Kirkbride saying is that the language currently does account for, so you are still required to have hands-on administration technique training related to the actual process, but that there is no specific carve out for that one subset of that. So if you're trying, you don't want to miss and say that hands-on is not required for the initial and setting a lower standard for a technician than a pharmacist to
Okay.
learn. So I think it's more of an awareness and an understanding that there might be different layers in how you assess to be compliant with this rule.
I got you. Like how did you,
Board Member Patel, no comments.
Alderman Smith?
For that, it's not.
Thank you. Corey, I start with you? Yeah, okay. Thank you. On that note, is there a motion to move to adopt temporary rule OAR 855-125-0305 as presented to be effective upon filing?
Move, Board Member Kirkbride.
Is there a second?
Second, Board Member Kroger.
Board President Joyce, yes. Board Vice President Kirkbride,
Yes.
Board Member Chin,
Yes.
Board Member Hall,
Yes.
Board Member Kroger,
Yes.
Board Patel,
Yes.
Board Member Smith.
Yes.
Motion passes.
And then, President Joyce, if you want to just read the next motion, that is
Yeah.
for mailing C.
CA, okay,
Correct.
correction. Is there a motion to move OAR 855-125-0305 as proposed to the November 2026 rulemaking hearing? Is
I'll move Board Member Chin.
there a second?
Second, Board Member Kroger.
Board President Joyce, yes. Board Vice President Kirkbride,
Yes.
Board Member Chin,
Yes.
Board Member Hall,
Yes.
Board Member Kroger,
Yes.
Board Member Patel,
Yes.
Board Member Smith.
Yes.
Motion passes. Excellent. We'll now review mailing C1 with Staff Member Effermoff.
Staff Member Effermoff, to orient the board and the public to this mailing. This is C1 for Division 43, specifically the dispensing practitioner drug outlet sections. These rules changes are being brought forth as we have identified a small change that can easily be updated in Division 43 in the dispensing practitioner section. And since we have the rules open for compounding division changes from 45 to 183, it made sense to also update these rules too. The board does have one board that utilizes this waiver specifically that we are proposing to amend the rule in that waiver exemption process, and they will be making a request for modification in the near future. So it seemed like good timing to be able to get this in order. And the board, this will be the board's first review of these rules. The proposed new language is bolded, underlined, and highlighted in yellow at the beginning of the line for any changes made, including additions or deletions. In addition, for ease of review, rule sections are proposed. The section is highlighted also so the board can see that that section has a change in that rule. Big picture for these rules is really to update to reflect the agency's current processes. As of 1/2024, the board transitioned to biennial inspection process and no longer complete annual inspections. So we wanted to get this rule in alignment with what the agency's processes currently are. Our standard rule review process is typically to go section by section, but since this is a first look and the scope of this is very limited, I think it might be best just to read through the rules in their entirety and then open all sections for board discussion. So I will start with division. So it's division 43. It's 855-043-0510. Paren 11. Staff proposes to have it read currently to have changed to read to the board may grant a time-limited waiver exempting dipto registration when a practitioner's licensing board submits a request to the board with a plan to inspect the dispensing facility as approved. And then moving down to the next section of 855-43-0560. We are just proposing in paren 2 to strike out a citation that is no longer applicable. This section has been moved to, it's related to inspections, and inspections were pulled into Division 104, I believe. So it is no longer applicable in Division 1. So staff is proposing just to strike it instead of adding a different citation. This section can read accurately with just the striking of that citation. So each dipto will be inspected on a routine basis, I think, per struck on a routine basis and must be scheduled in advance with the dipto to occur during normal business hours. So at this time, we'll go ahead and continue the round robin. And if we could start with board member Chin. Oh, no, I apologize, Hall. We just did Chin, right?
Yeah. Board Member Chen is next.
Board Member Chin has nothing to add. Thank you.
Overall, I have nothing to add.
President Joyce, routine, is that defined, I guess, every,
So just to give the board a little background on this process, so what happens is any board that wants to request an exemption from a dicto registration has to have the board review and approve a limited time waiver. So currently, the veterinarian board has a waiver that is good until 2029, but it was for a different inspection process. So we thought adding or striking this language to have it read as is gives the board a little more flexibility in what people bring forth, and hopefully will add longevity to these rules. So if you do change processes and how you do things with the intent of really having whatever agency is asking for their board to not have to register as a dipto with the Oregon Board of Pharmacy, that they would be meeting the standards of the Oregon Board of Pharmacy. So our standards may change. This would allow you to assess that on a case-by-case basis. And you still will be required per this rule to assess and issue a waiver to permit them. I did want to give one other key component of this too. It is helpful that other boards, if they are doing this to the standard we are, that is, for example, the veterinarian board is regulating their facilities and outlets, and that's around, I believe, like 700 extra licenses that were outlets that we are not currently having to inspect and regulate. So it is helpful for other sister boards to help do the regulatory process in partnership.
thank you.
Yeah, my question was kind of around that, where my initial reaction was, well, if we don't register them, how do we know where they are? But it sounds like they have they don't have an individual waiver, or they have an individual waiver that we would have a record of. So if we needed to know where they were, we could pull a record of the waivers. It's not a registration, but we could pull a record of the waivers and know where these were if we needed that information, or.
Staff member from close, yes. So it is the practicing licensing board who submits the request for the waiver. So in this situation, we have an example of the veterinarian board. So as part of becoming in compliance with this process, they started registering their outlets. So their outlets are now registered. They adopted rules to be in compliance with the board, to have a self-inspection form that's required, and that they inspect to that self-inspection form. They've also done training with some of our staff. So with that, they have a list, and we have on record publicly and in our records of their waiver and when it lists to. And then if we have any questions about an outlet, they would have a list and will provide the results to the board. Typically at the check-in of when they ask to re-up, they provide those results of what has been going on during their inspections.
Perfect. That sounds like a great process, and I love that that's many sites we do not have to inspect. Thank you.
Board Member Patel. No comments on that one.
Board Member Smith, looks good to me. Thank you.
Herbert,
No comments, thank you.
I'll hand it back to Board President Joyce.
President Joyce, yes, if you could entertain a motion for this as a temporary rule, and then mailing C1A would be also to send it to November rulemaking hearing.
very good. Is there a motion to adopt temporary rule OAR 855-043-0510 as presented to be effective upon filing?
I'll move Board Member Chin.
Is there a second?
Board Member Smith.
Board President Joyce, yes. Board Vice President Kirkbride.
Yes.
Board Member Chin.
Yes.
Board Member Hall.
Yes.
Board Member Kroger.
Yes.
Board Member Patel.
Yes.
Board Member Smith.
Yes.
Motion passes. Back to you, Staff Member Melvin first. Oh, let me go ahead and motion it then. Yes. Just talking to myself. Is there a motion to move to send OAR 855-043-0510 as proposed to the November 2026? Excuse me. Is there a motion to move to send OAR 855-043-0510 as proposed to the November 2026 rulemaking hearing?
Board Member Smith.
Is there a second?
Second, Board Member Kirkbride.
Board President Joyce, yes. Board Vice President Kirkbride.
Yes.
Board Member Chin.
Yes.
Board Member Hall.
Yes.
Board Member Kroger.
Yes.
Board Member Patel.
Yes.
Board Member Smith.
Yes.
Okay, motion passes.
Excuse me, President Joyce, I just realized there's an issue. We can motion, we need to add that second rule that's in the proposal is missing from the motion. So if you could read new motions with the separate rule, let me pull it up for you so I can show you.
Let's see in it.
Sorry, we just cited one OAR, not the second one.
Okay.
Give me just a moment. So you can use exactly the same language. So we need to send 043, 0560 was missing from each of those motions. So I'll file them all at the same time, if that makes sense. We don't need to unwind anything. We just need to move to adopt temporary rule for 043, 0560.
Do you want me to restate the 510 as well?
No,
Okay. Okay. So is there a motion to send OAR 855-043-0560 as proposed to the November 2026 rulemaking hearing?
Board Member Chin.
Is there a second? President Joyce, yes. Board Vice President Kirkbride.
Yes.
Board Member Chin.
Yes.
Board Member Hall.
Yes.
Board Member Kroger.
Yes.
Board Member Patel.
Yes.
Board Member Smith.
Yes.
Motion passes.
okay, and then if you can do it one more time for the temporary rule, and then we'll be good.
Okay.
Apologize.
So it's okay. Let's see. Um, same numbers or
Yes, so you're just going to motion to adopt temporary rule for 855-043-0560.
is there a motion to send,
No, motion
excuse
to
me,
move to
is there a
adopt.
motion to adopt OAR 855-043-0560 as proposed to the November 26th,
Sorry, Nope. Go up
Oh,
one.
okay.
This is the temporary rule. Okay.
I see it now. Okay. All right, is there a motion to move to adopt temporary rule OAR 855-043-0560 as presented to be effective upon filing?
Board Member Chin.
Is there,
Second, Board Member Kirkbride.
okay, Board President Joyce, yes. Board Vice President Kirkbride.
Yes.
Board Member Chin.
Yes.
Board Member Hall.
Yes.
Board Member Kroger.
Yes.
Board Member Patel.
Yes.
Board Member Smith.
Yes.
Okay, motion passed. Thank you.
Thank you. Sorry about that.
Temporary, permanent, whatever.
Sorry, C2. I was gonna say, I thought we were gonna do JE first.
We're ready to discuss UMPGA. Yeah, let's take a 10-minute break, come back at 11:05.
Sounds good. Thank you.
Here.